have Mr. Azman, the managing partner at RHTLaw Asia LLP, chairman, and the Asia Plus Group. Azman is a leading expert in merger and acquisitions and a corporate finance, driving technology adoption and regional transformation across ASEAN. He's also an ad hoc tutor at the National University of Singapore Law Faculty and a regular speaker on M&A, IPOs, and regulatory compliance. Thank you so much, sir, for your time today.
Singapore is often praised for its ease of doing business, but navigating a new market always comes with new challenges. From a legal perspective, what are the key legal and regulatory hurdles that European businesses should be aware of when expanding into Singapore?
Maybe I should answer that question in a rather interesting way. Perhaps there are actually quite few. In a sense that for the EU, where so much that you understand about regulation, a lot of Singapore is actually very pro-business, as Andrew, Ivan, and Amitabh has actually mentioned. So a lot of Singapore is actually, as much as a lot of people like to complain that Singapore is highly regulated, but it's extremely pro-business in the sense that the country sees itself as the springboard into the rest of Asia. And there's something important about this in the sense that this gives us an understanding about how rules and regulations will be formulated in Singapore. Singapore sees itself as a gateway into a larger ASEAN market of about 660 million people. So in that sense, a lot of how we regulate ourselves seems very much in line with trying to help foreign investors come into Singapore so that we can bring you to the rest of the region. Now, let me also point out a few things relating to some of the key legal aspects, or maybe even you might say some of the key regulatory aspects of how things can be done a little differently in Singapore. Now, in Singapore, there exists an organization called the Economic Development Board, which is in the business of attracting business into Singapore. Now, it also awards grants where at least 30% of the equity is locally held, and it provides tax breaks for innovation. Now, what it really means is that premium is placed on innovation if you meet the local equity requirements. Now, this also means that startups like what Ivan said could technically come to Singapore, work out with local joint venture partners, and then can even come under the scheme where they can avail themselves of some of these tax breaks. Now, over and above that, I think insofar as key legal and regulatory hurdles are concerned, immigration has always been a very, I wouldn't say problematic, but I suppose for a long time, it seems rather discretionary. So a lot of people have a lot of concerns over whether the managing director they're going to bring in from Texas is going to meet the requirements or not. But I think generally, if statistics would show that, some of these concerns are actually not very well founded. So expat workers generally, we're not very restrictive. I think it's quite transparent in a sense that, or at least with the introduction of some new evaluation metrics, it's intended to move towards transparency. So expat workers, whether you're seeking an employment pass or otherwise, it's relatively straightforward to come in. Even if you had come in under the old regime or the new, you should be able to, largely because it's a very qualification-based approach. If you've got the experience, you've got the qualifications, you've got the skills necessary for the job, you should be getting it. There's no real discrimination between whether you should get a local employee or a foreign employee, unless it's at a certain level, like when you have work permits and so on. Now, over and above that, sure, we do have data protection and competition law regulations, but those are, if I may say, as robust and probably to some extent maybe less burdensome than those you might find in the EU. So we do have them, but I don't think they're really in the way, or you might regard them as hurdles. They're pretty much part and parcel of the landscape in Singapore.
Thank you, Azman. That was really insightful. And it's important for companies to proactively address these challenges. Singapore is not only, heavily regulated, but it's pro-business also. That's the key point which I'm taking from there. How can businesses use digital marketing strategies to enter the market?
Insofar as digital marketing strategies are concerned, in Singapore, one of the key points that we always have to address when we deal with anything digital is the flow of data, or a cross-border flow of data and personal information. There's an entire body of laws that relates to this, but a lot of it has got to do with compliance. We don't have a lot of problems with data flows and digital marketing that may come into Singapore. from anything relating to Amazon to right down to Taobao in China, and right down to anything even relating to TikTok and any people who want to market through TikTok. All these are available. There is very little that one have got to be concerned about insofar as how digital marketing can be done in Singapore. Now, but one of the critical considerations that we should have is actually how some of these actually now attract cybersecurity concerns. So there have been a lot of discussions online about how cybersecurity should be addressed. There is a body in Singapore that deals with cybersecurity. Unfortunately, a lot of data protection and cybersecurity issues have caused some concern in the sense that it's increased the cost of doing business in Singapore because of the need to provide for such protections. So in the end, I think if you're concerned about the investment into digital technology and the like, Singapore is a very open market relating to this. However, there has been some development lately, but some people have expressed concern about this, but it's really got to do with some new laws relating to the protection of national interests when it comes to acquisitions by foreign parties. But the risk of that actually activating in any acquisition actually is very low. So there should not be any concern in relation to methods in which such things can curtail investment into Singapore.
Right. I think adding on to it, when a company is entering any new market, and they localize, the challenge that they face is normally like, how will you localize the content and all of those things. So I think Singapore or ASEAN is a very different market from the Europe market. And that's what we need to also consider, that you need to, when you serve the market as such, entering the market can be easier if you do a M&A deal or things like that. So can you please highlight like how M&A can help, quickly expand into the Asian market? I think that will be what I think our audience would also be interested to know.
Cool. Thank you, Bhargavi. Okay, so one thing we have to understand is that the Singapore market, as much as we are extremely open and pro-business, the markets around ASEAN are not necessarily similar. I won't say they're not as friendly. I'm just saying that the rules are different.
Exactly.
The data protection rules in Indonesia are different from Singapore, so there's a need to understand how we can comply. But one thing's for sure, there have been, because of no foreign exchange control in Singapore, other than the need to comply with AML requirements or anti-money laundering requirements, there has been a lot of inflows of capital into Singapore from, say, for example, Indonesia, right? Where companies that were originally set up in Indonesia actually then come back to Singapore to set up their base so that they can reinvest back into Indonesia. The same here happens for a number of MNCs that we know about. They set up in Singapore, then the Singapore company actually then controls everything else in Indonesia, in Vietnam, and elsewhere. I think insofar as connectivity is concerned, there is very little that is not understood between having a Singapore investment holding company that's at the top, or the top co, if you like. So in a sense, it is a very easy conversation to have if you say that, can we from Singapore set up in Indonesia, or can we set up in Thailand, or can we set up in Vietnam? Everybody will understand that, oh, this is actually how it's done. This is actually how we apply in Indonesia, for example, for a PMA company. And then these are the requirements. Now, of course, I wouldn't want to go into that because right now it's about Singapore, but in terms of the capitalization of, for example, an Indonesian company would be different. So you need to comply with Indonesian capitalization requirements for an Indonesian company, which will flow through from Singapore.
Yeah. So I think it makes very easy when you set up first in Singapore and navigate through the Asian market, spread your products and services. It's very easy once you've captured the Singapore market. I think that's what we probably take. And like Indonesia, India, and other parts of these places also helps you to have a product price strategies, everything in place very easily when you've just tapped into the Asia market. I think that's what probably we can also add on. So yeah, thank you.
Oh, yes. And by the way, because of the existence of a multitude of double taxation agreements,
Yes.
it is also relatively easy for countries to navigate cross-border between the investment holding and into their subsidiaries in all the other countries around Asia. That's what I would add. Thank you.
Absolutely. One quick follow-up question. I was interested in know how can European companies protect their IP during negotiations with local partners or when acquiring Singapore-based firms?
Thank you, Harpreet. The important thing about negotiating in any part of the world actually is applying your commercial common sense relating to this. Intellectual property is important. I think one must be mindful that we always start the discussion on the basis of where your protections can actually be enforced. So it's important to understand at the end of the day that one of the key attractions about Singapore is that we have a very robust dispute resolution framework that encompasses SIAC for arbitration, that encompasses the Singapore International Commercial Court. If you want a court process to deal with your dispute, or you can ultimately then submit to the Singapore courts for all your dispute resolution needs. However, when you go cross-border, I think the clever thing that one has got to do is, other than your standard approach to having a proper, well-enhanced NDA or non-disclosure agreement to protect your rights, you do, I believe, because of the different jurisdictions you're dealing with. In Singapore, it can be quite quick for you to obtain an outcome for for dispute resolution. In some countries, it can take a very long time. So one has got to be very practical about how you want to protect your intellectual property rights so that you don't give too much away for you to then start a dispute and then after that try to find resolution for that, because it will take too long. So one should be very careful about that. In practice, an NDA would work. Most people will have an NDA, non-exclusive jurisdiction of Singapore courts or SIAC if you need to. Then it's important to understand why you have the NDA. It's to observe obligations of confidentiality and other aspects of your ownership of the intellectual property. There's one other thing which I would usually advise clients who are venturing overseas from Singapore, is that a lot of Asia starts business on the premise of a very good and deep personal relationship with the parties you deal with. In many parts of the world, including Singapore, we tend to take the ability to enforce our rights for granted. But because you are crossing borders, it's always important to understand that this doesn't always happen like clockwork in many other countries. So if you don't developing the relationship will lessen your risk. So understanding how far you can go with this person, how well you've known the person. So in other words, what I'm also saying is that having to meet someone over 2 weeks in another country doesn't necessarily mean that you can get a deal done. In Singapore, you probably can, because it's extremely clinical. It's very transparent in Singapore. If you meet Mr. A and you know who Mr. A is, people will vouch for Mr. A for you. But in Indonesia, for example, or Vietnam, a character called Mr. A or Mr. B can be very hard. It can be very hard for you to understand where he comes from, how he might deal with you in business dealings, how you may or may not be able to trust him as much as you want. So to go beyond the ability to enforce is going to be important. So I would suggest that know the market well and build a strong enough relationship to deal with the risk of having to enforce your rights, especially in intellectual property, because it can easily be taken away from you.
Thanks, Azman. That was really fascinating.